Hello, everyone. I hope you are well. As it's just gone 12 o'clock, I'm just going to give people the opportunity to log on and join us. Got lots of people joining the webinar today, so I want to give everyone the opportunity to tune in before I start. Hello, everyone, and welcome to our October webinar. After the recent deluge, it's very nice to have a little bit of autumn sunshine, as you can see, shining upon me, and I hope that everyone is well. As I said, we've made it through to October, and what I wanted to do for this webinar is have a look at the state of play, where we are at the moment in terms of employment legislation, because we've got some new laws that have been passed recently. So I just want to touch on those. Obviously, October is a big month as well, as we know, for legal changes. And then I want to also have a look at the employment bill as well. So for those of you who are new, just joined us, and this is your first ever webinar, thank you very much for joining us. It's great that you've found us. The aim of our webinars is to kind of give you a legal update first and foremost, but also to bring you different voices and perhaps different ideas, hear from different people about things that you are impacting upon you in your HR practice or as business managers. So Boyes Turner are a full service employment law firm, commercial law firm based in the Thames Valley, looking after clients across the UK, Europe and globally. So as well as bringing you webinars and giving you information about employment law updates, I also run training courses. And I run training courses for clients. So I will go into clients, whether that's virtually or in person, and run training courses for their management population, as well as for HR teams. I was running a training course yesterday for an American client, giving their American HR team an employment 101 in 2.5 hours, which was no mean feat. But I do want to tell you about this course that I am running on the 23rd of October. Now, the reason I want to tell you about the Manager Masterclass is because it is my most popular course. And I want to give you, perhaps as HR professionals, maybe you've never experienced a training course before and you want to see what legal training is like, or maybe you've got some managers that also want to find out a little bit more about training courses that are available, or you've got a few managers within your business, so it's not really economically viable for me to come in and run a day's session for you. So this is an open course. It's a public course. The other good thing about a public course is you get to meet and network with other like-minded professionals, meet other managers, and also share practice across different organizations, which I always think is incredibly valuable. So if you are free on the 23rd and want to come and join me and my other attendees that are already coming, it's an in-person course. Mix of legal, so I'm talking about employment law for managers, looking at legal risk areas, as well as concentrating on issues from a manager perspective. So what do managers need to know? I'll be discussing employee relations processes, disciplinary grievances, etc. But one thing to note is I will be looking at the Equality Act and what it means to be an inclusive leader, as well as looking at some of the new obligations that we've got coming our way. So again, it might be something to look at attending, just because I'm going to cover off some of the things I'm going to be talking about today in a little bit more details. So I'll be sending out information about how you can book your place after the webinar today, but I really hope that you're able to come or recommend to your managers that they should also come. If you're interested about running the course in-house as well, again, please let me know and I can share with you a bit more detail. So what am I going to cover today? Well, I'm going to be looking at fire and rehire. I'm going to be looking at the new tipping laws. Then I'm going to be looking at really the big one at the moment, and that's looking at changes to sexual harassment laws. Then we will look at what is expected in the employment bill. And I've got some of the things I'm going to be talking about, and then we'll give you some tips and things to be thinking about over the next few months. Now, I've really toyed with the date of this webinar because I know the eagle-eyed amongst you will be saying, Emma, we don't have the employment bill yet. And I know we don't. We have obviously lots of speculation. We've obviously got the Labour manifesto. We've obviously just had the Labour Party conference where obviously we heard from various ministers about, what was planned. But we don't physically have the employment bill yet. We are expected to get that maybe next week. But again, there is lots going on, isn't there, in the world? So we will have to wait and see on that. But the difficulty was if I waited and delayed and did this at the end of October, then we miss the window to be talking about the changes to sexual harassment laws, which are coming in on the 26th. And I wanted to give you the opportunity to obviously hear about what they are and to take some steps now to get yourself ready and prepared. So yes, I appreciate I am jumping the gun when it comes to the employment bill. It's going to be still a little bit of crystal ball gazing, but I think with some degree of certainty, or certainly with a small c certainty as to what we can expect. What I can't tell you is when we can perhaps expect these changes to come in. But as I said, if I did it any later, we would miss the boat. Also, just remember that this is an overview, okay? If you've got any issues or any concerns or anything that you've heard and you think we need to be implementing some of those changes or we need to think about those things in more detail, then please, please, please get in touch. And there's my email address. But as I said, I'll be reaching out to everyone after the webinar anyway to give them some more details and information. So I hope that kind of clarifies what I'm going to talk about today. So the first thing I want to talk about is the new code of practice on firing and rehiring, which came out in July. So it's been around now for a couple of months. Really, this is important for businesses who are thinking about effectively ending employment. So what fire and rehire is, it's ending employment under the current contract of employment. And as we know, we must comply with all those fantastic notice provisions and other contractual terms. So it's about complying with those provisions. So giving notice under the current contract and then offering re-employment, so rehire under new terms and conditions of employment, which often are less favourable than the existing terms. So we do have a new code which sets out processes and procedures which employers should be taking into account if they are proposing to enter into fire and rehire. And we're going to see this magic number 25% crop up on a couple of slides today. If this new code is not complied with, then just like the ACAS code of conduct in relation to disciplinaries and grievances, if a claim is successful in the employment tribunal, employment tribunals will have the power to increase compensation by up to this magic figure of 25%. So it is something that employers need to think about. And we need to be thinking about it in terms of consultation, so discussing plans with employees or their staff representatives, whether that's be a union, for example, but also not just talking about it for talking's sake, making sure that those consultations are meaningful, but you're having those discussions with staff to tell them obviously what the proposals are. Fire and rehire should be a last resort. And it shouldn't be, this is what we're going into and this is what we're going to do. And again, it mustn't be used to threaten employees. to accept any contractual changes. So again, remember fire and rehire, but also please remember the collective consultation obligations, which may be triggered in what you are proposing to do. So if you are thinking about changing terms and conditions of employment, please do take advice, particularly around the potential numbers of employees that could be impacted by any decision to fire and rehire. And that's a key point. I popped in there at the bottom of the slide, Labour plans, because this is something which, Labour and obviously the unions which support Labour are not particularly keen on, as you can well imagine. So there may be some plans, certainly some have been mooted, actually to sort of do away with fire and rehire altogether. So it might be something to, even though you have a code and we have to follow the code because, as I've said, there's potential consequences there with regards to compensation, it may be that this is something that businesses look at in light of the fact that it could be something that goes later on under Labour plans. So just watch out and be aware of that one. Tipping, again, for our leisure and hospitality clients, although applies across the board to where there's tips, but certainly relevant to those sectors. There is some new law that came in literally on the 1st of October. So it is very much new law. And there is also non-statutory guidance that the government have also published, which is well worth looking at as well. Key things there, it's to do with monies, whether that be cash money or money paid via credit cards, so service charges, that the employer is in control of. So the 12.5% or whatever it is that's added to bills, etc. The other thing to remember, it's that wider category. It's not just employees, but also workers and agency workers as well are entitled to have a share of the whole tip pot. Employers can't take money out of the tip pot for things like administrative costs. It's the whole pot. And again, it has to be paid, passed on by the end of the following month from when it's received. So it's not something that employers can sit on and hoard and then pay out once a year. There is this, there should be this constant flow of tips. Again, although it is employers who can decide who shares the tips. And again, remember, if tips are not fairly distributed, or if the employer fails to provide the workers with information, so workers are able to ask to see how tips are allocated and also any policy that the employer has. And again, if that's not complied with, then it could be an employment tribunal claim. So there are it's legislation that has some teeth. So again, something to think about, particularly for those of you in the leisure and hospitality sector. Now, this is the reason why I didn't want to wait and hold the webinar at the end of the month, because we would miss the boat really for the 26th. I know there's been lots of articles, and I'm sure lots of you have been attending training sessions and other webinars looking specifically at what this obligation is. For those of you who haven't, it's not come across your desks yet, it is something that you need to tune into and really focus on. So what we have is, obviously we have the Equality Act, and within that we have the right there, that protected behaviour of harassment based on a protected characteristic. But we also have another element of harassment, and that is specifically in relation to sexual harassment, which is defined as conduct, unwanted conduct of a sexual nature. So that can be, for example, inappropriate comments, lewd behaviour, inappropriate touching, right up until very, very serious cases of sexual assault. So it's unwanted conduct of a sexual nature, which has the purpose of effective violating a person's dignity or creating that hostile, intimidatory environment. So this new law, this new legal change applies specifically to that area of harassment laws. Now, of course, harassment law in its wider sense, protected characteristic, and also where an individual has either ended a relationship with a colleague or some less favourable treatment, or if they have spurned advances from a colleague as well. So again, we have to think about that. And again, we've still got the statutory defence, and we should be putting in place all the good stuff that those of you who've been on my training courses will know that I talk about. But this is a new piece of legislation. And what it does is that if an individual is successful in bringing a claim which includes an element of sexual harassment, then there is a duty on the tribunal to then consider what reasonable steps the employer has taken to prevent sexual harassment occurring in the workplace. So it's not a standalone claim. It's not somebody who can, a worker can't bring a claim against you, an employee can't bring a claim against you because you haven't got employment and manager training. But if there is an allegation of sexual harassment, unwanted conduct of a sexual nature, and if then the individual brings a claim and is successful, then the question of whether or not you've taken reasonable steps, which can include, legal manager training, will become an issue. But it does, if you like, place a positive and proactive duty on employers to take these preventative steps, these reasonable steps. And reasonable steps is going to depend on the employer. It's going to vary from case by case. And also it can vary per part of a business. So for example, you might have a particular business that has a retail arm. So you've got individuals, your employees who are coming into contact with members of the general public. So third-party risks there. You may have an area of the business that works entirely remotely. And again, what are the risk areas there? And then you may have an area of the business that works in a hybrid fashion as well. So, risks of being in the office, risks of being online. So it's certainly not one size fits all, and certainly not one size fits all in relation to any one business. So we're thinking about the size of the employer, we're thinking about the sector, we're thinking about the working environment and the different working environments. So I think this is something that we do need to focus on. So as I've said, it's not a standalone claim, but if a claimant is successful in bringing a successful claim where sexual harassment has been part of that claim, then again, there is that, magic 25% there. Then the employment tribunal must consider what reasonable steps the employer has taken and assess compensation and potentially increase that compensation by up to 25%. We're obviously going to have to see the interpretation of that in the courts once we start seeing cases coming through, but I do think it's going to have a rather wide interpretation. And also remember that, compensation for discrimination and harassment is potentially without limit. So you start adding 25% on to compensation, it could potentially have an incredibly impactful consequence on employers. There are also new powers for the Equality and Human Rights Commission, so as well as obviously tribunal claims that can be brought in that compensation issue there. Then also we have to think about the Equality and Human Rights Commission. Now they have produced new technical guidance, which is worth a read, actually. It's worth having a look at. There's some nice examples in there and also some sort of tips of things you can do. But, don't forget, the EHRC has very wide powers in relation to sexual harassment claims, so potentially can get injunctions. We could be looking at investigations, legally binding agreements, and also, naming, shaming, etc. So there is an element of reputational damage here that needs to be considered. So what are reasonable steps? Well, as I've said, reasonable steps will depend on you as an employer, who you are, what you do, and how you do it. But in terms of things that you can do practically, and again, it's helpful to have a look at the Equality and Human Rights Commission guidance here. The key thing for you as HR and as a business is to engage with this, okay? Because this could potentially be, a very costly exercise if you are not engaged and you're not taking these issues seriously. So my first tip is for managers, boards, HR teams, have this on your agenda, and also have it on your board agenda and your meeting agendas as well, because this is something that is going to be a kind of a moving piece of work, I can see. Because, with the time remaining, we're not necessarily going to hit every target before the 26th of October. So engage. The other piece of advice is obviously to risk assess, because if you don't risk assess, looking at where the potential issues may arise, how are you going to know what reasonable steps you need to take? So I think that's an important thing to think about. What are we going to do? What does our business look like? Are our people, mixing with or coming into contact with third parties? Now, third parties is an interesting one because it is not in the legislation. So there is no right for an individual to bring a separate claim for third-party harassment. However, we know that it is in the technical guidance for the ECHR. So the ECHR envisage that this law is going to be used where there is third-party harassment. So the advice is actually to include the risk of third-party harassment within your risk assessments, and obviously any procedures and policies that you put in place to obviously take those preventative steps. So the key thing, risk assessments. Again, easy win, policies. Make sure your policies are up to date. Not just that, please make sure that your policies are clear, that you define sexual harassment, that you give examples, you make very clear who is responsible, make very clear how to raise concerns. And again, make sure you're very, very clear in terms of what the consequences are. What happens if something goes wrong? Again, have we got any lessons that we can learn? If there have been previous complaints, how did we deal with it realistically as a business? So did we really have an open culture? Did we keep things confidential? What was the outcome? So what are the lessons learned? You're going to hear me use the training word a lot, but that's because it is important. Because again, if we don't tell people what the risks are, we don't dispel the myths about sexual harassment in the workplace, we don't dispel the myths about who can bring a claim under these new laws, and who can say that their working environment has become intimidatory or hostile. Because I think there's a lot of myths around this piece of legislation, and particularly around the area of harassment and sexual harassment, that I think is worth discussing and reviewing with your managers. So board level training, manager training, employee training, and then thinking also about third parties. So for example, if you have an area of the business that works with in a call center, for example, what can you do to alert third parties, i.e. customers, to the fact that you take sexual harassment very seriously, and what's going to happen if somebody alleges that they've been sexually harassed by a customer. But again, we know, don't we, it's all well and good having all this wonderful stuff in place, but unless we're reviewing it and monitoring it and making sure that we're making changes where we need to, it's worthless, isn't it? So again, it's about taking those practical steps, having it on your agenda. I think it's going to be a really good point. A couple of questions here about what would be the right and appropriate in terms of an average time frame to deal with a sexual harassment claim? Again, there is no time frame. It's going to be what's reasonable in the circumstances. And again, we know in these types of situations, they can become very delicate because, again, we've got situations where perhaps somebody goes off on sick leave. So how can we manage that? Certainly, we don't want to have allegations hanging over people's head for a long time because, again, we have to balance, don't we, the needs of the individual who's raised the concern. And again, we need to think carefully about the language as well that we're using here. Maybe victim might not be the most appropriate word to use in these circumstances. So I think that's something to think about as well. You've got to balance the needs and the duties that you have, not just to the individual who's raised the allegation, but also to the individual who has been accused as well. So I'd say, it would probably be a matter of, months, shorter the better, but long enough to make sure that you've gone through a fair process would be my advice there. Training for employees or for all workers, such as including contractors and consultants. Likewise, the policy relevant for all workers or aimed at employees. Certainly, we have to balance, don't we? And I'm sure those of you who've joined previous webinars when I've been talking about, employees and contractors and making sure we keep that separation. However, in reality, there are some rules that your contractors need to know about. Certainly things around your harassment and your discrimination laws. So whilst it might be that you include all your workers in your training, it might be for contractors and consultants. What I would be doing with them is I would be perhaps, making them review and read and be subject to your policies on this, but also putting something in your terms and conditions with your consultants and your contractors, which states, we take our obligations very, very seriously with regards to harassment, and also making it clear that they will follow your rules and your conduct in relation to this. But again, there's always that balance, isn't it? We want to keep our contractors and our employees separate because they are, but again, in reality, there are some rules that we need to think about. Would you suggest anything raised, sexual harassment, can be handled under the grievance policy, or do we need a separate policy to handle these situations? It is up to you as an employer. We will have to wait and see what the employment tribunals say when these cases start coming through. Some businesses I know will have a separate line of communication if these allegations wish to be raised. I think the key thing is whether you run these complaints through your grievance process or a separate sexual harassment complaints process, it needs to be clear in terms of who you raise your concerns to, but also knowing that if you do raise these concerns, that they will be taken seriously and sensitively. So again, a lot of the time we think about, how we're going to have our policies and our processes, but actually fundamentally, this is about what it means in practice. So if people do raise concerns, is this going to be something where it's going to be, brushed under the carpet there, don't say anything about it? Or actually, are we going to take these issues seriously? So you can think about having, nominated individuals, you can think about confidential helplines, you can think about maybe having, some sort of champion to raise these concerns to. But at the moment, unless and until we've got, there's some discussion around this should be very similar to whistleblowing. Yeah, and I've seen that as well, and I've heard employers raising issues about that, whether we have some sort of confidential hotline that people can raise concerns about. I think, if people do, we want people to come forward and we want people to feel that they can raise concerns in a constructive way and in a way that actually, as an organisation, we take things seriously. So it's about, yes, having a process in place, but again, making sure that we're creating that environment where people feel that they can come forward. So yes, have your process, but really test yourself. Is it really open? Is it really accessible for everybody? And, unless and until we start getting these cases through, and we start, the employment tribunal starts looking at these cases and saying, okay, employer, okay, respondent, what have you done? Then it's very hard because we're sort of looking at things slightly in isolation. Yes, we have some tips, and yes, the Equality and Human Rights Commission guidance is incredibly useful, but I do think, we are going to have to wait and see. But certainly, the more you can be doing now in terms of raising concerns, in terms of, making it obvious, making it visible that you don't tolerate this behavior as an organisation, making it very clear that if people wish to raise concerns, this is how they can do it, and be rest assured that we will take these concerns seriously. Again, maybe having people, a dedicated person who complaints are raised to. But again, it's not just about having a policy, it's about your whole culture. And I think that, yes, a lot of the, training policy, tick, tick, but it's about the culture and how people truly feel about working with you. So one of the suggestions that I've heard about is about actually engaging with your stakeholders. So whether that's your employee forums, maybe union, or maybe your staff in general, and actually asking them, what reasonable steps do you think that we could take? Are you aware of any situations? How could we have handled it better? It's very difficult, because what we don't want to do is, obviously, this is not about kind of going down any sort of witch hunt, but actually, if you engage with your people and ask your stakeholders what their views are, and then actioning any suggestions that they put forward, because again, there's no point asking people things if we're not then going to put things in place. So again, putting those things into place, again, it's all about creating this open and transparent working culture where it's very clear through the training, what are the accepted behaviours, what are those good behaviours that we're looking for in our employees, in our managers, in our boards, making it very clear to our contractors, consultants, and those third parties that we interact with. Again, this is our policy, these are our rules, and this, we won't tolerate those being breached. But then having this, overarching culture of, inclusivity, and making sure that people feel that they work somewhere where their environment is not hostile, is not degrading. So it really is about having the full picture when it comes to what are reasonable steps. And again, a lot of this we are waiting and seeing. But we are helping businesses. We are carrying out lawyer-led risk assessments. So again, we can help you identify what those risks are, and then obviously put recommendations in place, be that updating your policies or looking at training. We can also simply update your policies as well, particularly around disciplinary grievance, particularly around obviously discrimination and harassment as well. And again, training. So I'm doing virtual training, in-person training for boards, managers, and employees. And as I said, this is something I am going to be looking at in the manager masterclass as well. So again, it's something, if you haven't already booked and you're interested to hear more, then again, please do book on. Also, if you are interested in me running a virtual course, a public course, I'm happy to do that as well. So again, just be interested to know what you're thinking about, whether it's something you would want to do internally, or whether actually doing a public open course that people can join. Again, that might be something to think about as well. So just let me know. But as ever, get in touch if we can help. So October the 26th, that's kind of the key date for most of the clients that I'm talking to. And it is something that I would, start putting now on the agenda. So there are some things that you can do now, but this is something that should be, on the HR agenda, also on the board agenda. I would say as a standing item, where are we? What have we done? Have there been any issues? Is what we're doing effective? Can we be doing more? And it's one really to keep an eye on, particularly as we see those cases coming through. So maybe towards the sort of middle to end of next year, but certainly focus on it now. At least have a plan and a timetable in terms of what your reasonable steps are going to look like. So it might be the first thing that you're going to spend this month doing your risk assessment. as well as updating your policies. And then it might be maybe moving forward, then we're looking at implementing some training, looking at implementing some other measures, perhaps around awareness, posters, those sorts of things. So there are things that you can do, but certainly being able to demonstrate that you have a clear plan as what you're going to do for your reasonable steps, and also speaking to your stakeholders. Again, I would recommend that you do that as well. Won't it be next week? The bets are on, aren't they, really? It was supposed to be here within the first 100 days. If you look at what 100 days is, that's a weekend, and legislation isn't passed or isn't published, I should say, at the weekend. So, it is something that we will wait with bated breath. But I do think, really, we have been talking about this, hearing about this for a while now. So, we do sort of know where we are in terms of what can we expect. Obviously, we had the King's Speech, didn't we, in July? There are sort of 3 key employment bills, if I can call them those. One is firstly the employment bill. That's primarily what I'm going to be talking about for the last part of today's webinar. And then there is the equality, race and disability bill, and there's a skills bill as well. So what we're looking for is that employment bill. And as I've said, it applies to Great Britain. So England, Scotland, Wales, Northern Ireland will have its own devolved rules, so it's really up to them if they want to, the Parliament there, if they wish to follow. But the employment bill will apply to Great Britain. And there are over 60 proposals, so we are still waiting to see which ones make the cut. But I think we do know roughly what we're looking at, and I do think this is the one that we're going to see, this day 1 right for unfair dismissal. I'm getting a lot of questions from my HR clients. I'm getting a lot of very confused expressions from managers in the training that I'm doing about this, because we've kind of got used to this 2 years. Yes, we've got the automatic unfair dismissal, we know about that, but we've sort of got it in our psyche that we do have 2 years, obviously discrimination laws and other day 1 rights aside. So it is going to be a cultural change within our organisations. We're going to have to be thinking a lot more closely and clearly about our onboarding processes. What does this probation period look like? So yes, the right to be unfairly dismissed is going to be a day 1 right, probably in the next sort of 12 months. So what does it mean? Yes, there is going to be a carve out for a probationary period, but that doesn't mean that you can just dismiss people within the first 6 months of employment, if that is the chosen period. The last thing I read, there was some debate between the Deputy Prime Minister's office and the Business Secretary's office around whether it was going to be 6 months or 9 months. So again, query what the length of time is. But even so, I just can't see they're going to give employers carte blanche to just be able to dismiss people within the first, say, 6 months of employment. Employers are still going to have to show that they've followed a fair process, that it's open and transparent, and that you're not just dismissing somebody because they've only just started, you're dismissing them for a quasi-fair reason. So I'm not entirely sure at the moment what this carve out actually gives us, but what it does mean is we are going to have to focus a lot more on our probation periods. And whereas, we might have managers coming to us after 6 months and saying, oh, this isn't working out, we need managers to be much more focused. We need those reviews being carried out, and we need the evidence to be able to support the fact that if we wish to dismiss somebody within their probation period, that we are doing it for a fair reason and we have followed a fair process. So again, it's going to be a big change there, but it's something that HR can influence and start thinking about it now. The other thing to think about is that if you have maybe you've got managers who've been putting off making decisions about individuals perhaps they haven't quite hit their 2 years service yet. It is worth revisiting those and also, looking at where you are in terms of employment need moving forward. So trying to make any decisions before the law changes on this. So again, make sure your probation periods are up to scratch. Make sure we're having our meetings. Make sure we're having our lovely meeting notes that are being taken, because again, it's all about the evidence of that being to support. So that's going to be a big one. The other change, and again, a lot of these are what I would call kind of a bit sort of low-hanging fruit. And parental leave is a key example of that. Parental leave is that unpaid leave, will continue to be unpaid, but rather than having to wait for 12 months, it's going to be an entitlement for individuals, employees from the first day of employment. So again, it's a bit of a low-hanging fruit there. Again, we've sort of, maybe we've done all we can do with flexible working. The government have proposed that they want to make flexible working the default from day one. Well, employees have the right to request flexible working from day one. So I'm not entirely sure what more changes can be made under the employment bill. And certainly, we saw changes, didn't we, in April of this year with regards to the protection for certain individuals on certain family leave with regards to suitable alternative employment if they are at risk of redundancy. This is obviously taking that to the next level, which is it's not just about, giving people access to suitable alternative work during maternity leave. This is saying actually that you can't dismiss an employee as redundant within 6 months of returning from maternity leave. So again, yes, there are some exemptions. We don't know what they are. I would imagine it's going to be, subject to very extreme business need. So we will have to wait and see. But again, that's something to think about. We've already got changes to redundancy. This is going to be another layer on top. So it's about remembering where our people are, what kind of leave they are, and obviously this protection for our returning mothers for 6 months, and they cannot be made redundant unless they are exceptions. Again, I can see some changes to carers leave, maybe not immediately, but certainly, again, it's a bit of a low-hanging fruit, isn't it? That we can, at the moment, carers leave, as we know, is up to 5 days of unpaid leave. There's the potential there, isn't there, to make that statutory paid, as in statutory maternity pay, statutory adoption pay. And again, an extension of bereavement leave. We already have parental bereavement leave, but this is looking at extending that right potentially to cover other bereavements. I can see this will be a sort of a quasi-dependent. So as we see for emergency leave, dependent is somebody who is a child, a parent, a partner, a spouse, somebody to whom you lives with you who's not a lodger or a tenant. So again, I can see something around there, but so that's something to think about, putting compassionate leave onto more of a statutory footing. National minimum wage changes, national living wage changes. There has been a proposal, hasn't there, to get rid of the 18 to 20 age bracket and really just make the national living wage applicable to everyone over the age of 18. That's going to be an interesting one, and it's going to be interesting to see. It's very interesting to see what impact this is going to have on youth employment as well. So again, watch this space, and again, reform of the apprenticeship levy, which, again, is one where I can see we need to have lots of clients who want desperately to, use apprenticeships, but they find that, the levy inaccessible. So hopefully some positive changes there. Again, another sort of bit of an easy win, if we can put it that way, for the headlines is around statutory sick pay, so SSP, so improved SSP, which effectively means that SSP will be payable to all workers from day one of sickness absence, so no longer any waiting days, and removal of that lower earnings limit. So again, bringing more of your workers into that bracket to receive SSP. So again, something to have a look at and consider when that comes into force, but also, you know, keep your policies and processes up to date with things around absence management as well, and keep things under review. There was talk about a ban on 0 hours contracts. No, this isn't a ban on 0 hours contracts. You are still able to use 0 hours contracts, but it's about exploitative 0 hours contracts. So making sure that you know, employers give adequate notice to their workers if they wish to change a shift, notice if they wish to cancel a shift. A bit of good news is that many of you will have perhaps read about, I know I was writing about it earlier this year, the predictive hours legislation that had actually been passed. Under that, there was a sort of a similar process to flexible working. So after 26 weeks, so not a day one right, as we have the flexible working, but after 26 weeks, a worker would be able to write to their employer and say, I want more predictable working hours, please. And then, you know, the employer saying yes or no based on statutory grounds for saying no. That piece of legislation is not now going to formally be enacted. So that's one thing we don't need to worry about. And I think that's because of this potential ban on exploitative 0 hours contracts. So maybe having that piece of legislation and this proposal would be too confusing. So we're going for this if and when it appears in the Employment Act. And there will be a new employment police force, if I can call it that, the Fair Work Agency. Again, it's going to be very interesting to see what their remit is, what their role is, what their powers are, particularly around investigations, so coming into places of work to investigate. Also, how this Fair Work Agency fits with the Equality and Human Rights Commission, ACAS. So there's lots of kind of seeing how all this sort of fits together. But yeah, Fair Work Agency, again, that's going to be a very interesting one to watch. We're going to have some changes, perhaps not unsurprisingly, to the laws around strikes. So we saw, didn't we, the Minimum Service Level Act was passed under the previous government, and the new government have said that they're going to repeal that piece of legislation. So perhaps no surprises there. And some general strengthening around trade union rights, and some changes with regards to balloting of members. So again, sort of making it a little bit more digital as well. So the employment bill, again, there's things to think about there, unfair dismissal being the main one to consider. Draft equality bill as well. We will wait and see when this is published. This sort of area is causing slightly more difficulties because what the government are proposing to do under this bill is to create an equal pay claim, as we have under the Equality Act, where men or women can bring claims that their pay for doing like work or work which is equivalent or rated as such is different. And what the proposal is that there will be an equal pay claim for individuals to bring claims that they are underpaid because they are disabled when compared to non-disabled individuals. That's causing a few issues over definitions. So again, let's wait and see on that one. But there are proposals to, as we have gender pay gap reporting, mandatory gender pay gap reporting, again, ethnicity and disability pay gap reporting as well for businesses with 250 or more employees. So again, some changes there, more reports, and some things to watch. So where are we? Wait and see. Single worker status. So that was the idea of that we will have, you are either a worker or self-employed. So at the moment we have employee, sort of hybrid worker, and truly self-employed. This is to have basically you are either one or the other. So we will wait and see on that. As I've already mentioned, third-party harassment may be coming in as a specific legal requirement. So amending the Equality Act there, again, we will wait and see, but I think it is something that will happen. Looking at paternity leave, again, that was something that was already on the agenda to have a look at, whether, you know, paternity leave was actually too low, whether we needed to extend statutory maternity leave. Again, looking at some consultative changes there, some process changes with regards to redundancy, collective redundancy and TUPE. And the right to disconnect as well. That's going to be interesting to see. There's been lots of talk, hasn't there? Lots of things being written about, you know, the 4-day week and right to disconnect. Again, we will have to wait and see what comes out. So there are some things that we know about. Obviously, your key HR focus for the next month, I would say, is around the sexual harassment changes. So hopefully what we discussed earlier will give you some guidance in terms of what you need to be thinking about. And obviously risk assessment is the key. It's the key which unlocks everything else, isn't it? Unless you know what the risk areas are, how can you possibly take those reasonable steps? So again, if you want to learn more and hear more about our risk assessment support, then again, get in touch with me. And then really the employment bill, yes, published next week, but we sort of know, don't we, what we can expect, and that will be within the next 12 months. So there are some opportunities now to get ourselves prepped and ready, particularly around updating your policies and your processes, really focusing on that onboarding process. I'm doing lots of training with managers and supporting them in terms of helping them understand the performance management process, particularly in relation to the onboarding process. Again, more and more training, please, for boards, managers, sexual harassment training, equality duty more generally, because don't forget, you know, we still have to think about the equality duties, you know, and the Equality Act and our obligations under there. Still really important to think about, you know, as well as obviously the sexual harassment changes. So be prepared. And if you want to know more about the manager masterclass, either you want to book on for the 23rd of October or looking at running yourselves, then again, please do get in touch. There's my email address. But again, I'll be writing to you all. Brilliant questions and comments. Yes, this is recorded, so I will be sending out a link as to how you can you know, find out more and listen again. But thank you so much for joining me, and I really hope to see you on the next webinar. All the best, and hope to see you soon. Thank you very much for joining me. Bye bye.